5, 4, 3, 2, 1, start. The only plea of the respondent oblique tenant in the application for leave to defend qua ownership is that other persons claim to be the owner full stop. However, it is not as if the petitioner has not dealt with the said case in his petition for eviction full stop. The averments in that regard were also not controverted by the respondent oblique tenant in the application for leave to defend full stop. It is the case of the petitioner oblique landlord that one Kishan had instituted a suit claiming to be the owner oblique landlord of the property against the respondent oblique tenant herein and the another tenant in the house full stop. Stanza. The said suit was decreed ex parte full stop. Though the petitioner was not a party to the said suit, but upon executing being filed by Ramesh of the ex parte decree and the petitioner oblique landlord learning of the same filed objections under order 22 rule 48 of the CPC in the said execution claiming himself to be the owner oblique landlord of the house full stop. The respondent oblique tenant herein at that time also applied to the same court for setting aside of the order of ex parte decree against him full stop. The petitioner has placed before this court the order in the said execution and by which order it has been held that the petitioner oblique landlord is the owner oblique landlord of the house full stop. The said order was made in the presence of the respondent oblique tenant full stop. Thus, in the face of the said documents, the plea of the respondent in the application for leave to defend of persons other than the petitioner claiming to be the owner of the property cannot be said to be such which needs to be put to trial full stop. Besides the aforesaid Ramesh, the respondent has also named Sri Parameshwar Munshi also as a person who was collecting rent of the property full stop stanza. However, the petitioner has again in the petition for eviction itself contended that the said Sri Parameshwar Munshi is none other than his brother-in-law who was collecting rent and dealing with the respondent on behalf of the petitioner and owing to the petitioner then being abroad full stop. Even otherwise, in the face of the documents of title of the house in favor of the petitioner and non-traverse thereof and the findings in the execution filed by Ramesh, the belled plea of Shri Parameshwar Munshi being the owner and oblique or claiming rent from the respondent oblique tenant is not such which needs to be put to trial and the plea is found to be vexatious full stop. It is not the case of the respondent oblique tenant that upon the petition for eviction being filed by the petitioner, the respondent oblique tenant approached Sri Parameshwar Munshi or that Sri Parameshwar Munshi has set up any title to the house adversely to the petitioner full stop. Moreover, the respondent has not denied the averment in the petition of having been inducted into the premises as a tenant by the petitioner acting through his brother-in-law full stop. I thus find that no ground for leave to defend qua the claim of the petitioner of being the owner is made out full stop. Once the petitioner oblique landlord is held to be the owner of the house under section 2 within bracket L of the act, an owner is also the landlord full stop. In any case, the rent is admittedly paid to Sri Parameshwar Munshi and who as aforesaid was collecting the same on behalf of the petitioner full stop. Thus, the relationship of landlord and tenant is also established full stop. There is no plea in the application for leave to defend of any alternate accommodation being available to the petitioner in the city of Delhi full stop. Thus, the outcome hinges hinges on whether the respondent has in the application for leave to defend raised any plea which, if established by evidence, would lead to a conclusion that the petitioner has no requirement for the premises full stop. The respondent oblique tenant has denied that the petitioner oblique landlord has requirement and oblique or that his requirement is bona fide, and besides the same has merely stated that the petitioner has been living abroad, has never lived in India, and has no intention to live in Delhi full stop. However, the respondent oblique tenant has not controverted the averments in the petition for eviction of the petitioner oblique landlord having been employed with British Railways and having retired in the year 1996 bracket start. The petition for eviction was filed in 2006 bracket close full stop. The respondent oblique tenant has also not pleaded any interest oblique vocation oblique business of the petitioner oblique landlord which would keep him in UK and oblique or which requires him to be in UK only full stop. In this regard, it is significant that the respondent oblique tenant was inducted as a tenant in the premises more than 15 years prior to the institution of the petition for eviction full stop. It is not anybody's case that during the said period of 15 years the petitioner ever got the rent increased from the respondent or threatened the respondent with eviction at any point of time full stop. The conduct of the petitioner oblique landlord shows that the petitioner oblique landlord sought to evict not only the respondent oblique tenant but also the other tenants in the house only after he had retired from his employment in UK full stop stanza. The petitioner has pleaded that he and his wife would settle down in the house in their old age and desire to come back to their own country in the last stage of their life full stop. Except for a bald denial, there is no contravention of the said plea also full stop. There is no plea that any action or conduct of the petitioner shows otherwise full stop. The senior counsel for the petitioner oblique landlord has in this regard drawn attention to the judgment of the Supreme Court full stop, though that judgment was on the provisions of the East Punjab Rent Restriction Act 1949 relating to NRIs, but the law laid down therein is of general application full stop. The Supreme Court took up for adjudication the contentious issue relating to the standard of proof required by the NRI landlord to prove his requirement of the accommodation from which ejectment is asked for and the factors to be considered at the stage of granting leave to defend full stop. It was held that the legislative intent is of expeditious disposal of the application for ejectment of tenant filed on the ground of requirement by the landlord of the premises for his own occupation. A special category of landlords requiring the premises for their own use has been created. If there is any breach by the landlord, the tenant is given a right of restoration of possession. The landlord who evicts a tenant on the ground of own requirement is not only prohibited from letting out the premises or disposing of the same but also required to use the same for his own residence only full stop. It was held that these restrictions and conditions inculcate inbuilt strong presumption that the need of the landlord is genuine. The conditions and restrictions imposed on the landlord make it virtually improbable for the landlord to approach the court for ejectment of tenant unless his need is bona fide. No unscrupulous landlord in all probability under this section would approach the court for exactment of the tenant considering the onerous conditions imposed on him, full stop. It was further held that this inbuilt protection in the Act for the tenants implies that whenever the landlord would approach the court, his requirement shall be presumed to be genuine and bona fide, full stop.